Hi everyone, I'm Emma. I competed in client interviewing in 2020 and I was lucky enough to win the grand final with my partner. And I have judged client interviewing both junior and senior last year. So I do have quite a bit of experience in this particular competition, and hopefully I can share some interesting tidbits with you today. So first of all, what is a client interview? So it's basically a initial conversation that you have with a client. Take it as your first meeting, essentially. So you sit down with them and just say, okay, let's give you some initial advice. Let's hear what's going on, that sort of thing. So it's just a 30-minute conversation, and it's one of the upsides of this competition is there's a lot less prep than something like mooting. So often you're only given a little bit of information to work with to prepare. So it's a lot less initial preparation. So it's 2 rounds that everyone competes in, you and your partner. And then after that, depending on your scores, you'll proceed through to the quarterfinals, and then it becomes a knockout. So you may then, if you win in the quarterfinals, proceed to semifinals and then grand finals. So in the quarterfinals, there are 8 teams, semis there are 4, and then grand final, obviously there are 2 head-to-head. Yeah. So the memo, so that's basically the main bit of information that you get to prepare before the interview starts. So you get a few lines of information. It's basically a pretend email from a secretary saying such and such called, this is their issue. And so they'll say their name and they'll give you 1 or 2 hints about what the interview will be about. So whether it's about contracts, whether it's about criminal law, whether it's about tort, something like that. So you might get something like, oh, Mr. Smith called and he mentioned something about his neighbor being very noisy. And so that gives you a little bit of a hint that it might be about negligence. Nuisance, I should say. And you will get that a couple of days before the interview weekend. So you'll typically get it like Wednesday or some couple of days before. So it just gives you a bit of a heads up about what areas of law you might need to look into and brush up on if you haven't studied them in the last 6 months, for example. That there are lots of good resources on Google. Have a look back over your notes if you've studied the subject. Otherwise, LexisNexis and Notepool as well are pretty good. So what you will need to know is the Australian Solicitors Conduct Rules, especially the ethical obligations around confidentiality. So that's something that you want to touch on in your introduction. So typically you sit them down, you have a bit of small talk, which I'll go over everything that you should say in the introduction in a minute. But one thing that you really do need to flag with the client is there are some particular rules around confidentiality that you need to be aware of. So you typically say something like, everything that we say here is confidential, pursuant to some exceptions, such as if we fear that there is the likelihood of possible harm to you or someone else, or if there is the possibility of the probable commission of a crime, something along those lines. So that's just something that you'll need to basically memorize and keep in your head to bring out in your introduction. But that can easily be found by Googling the the Solicitors Conduct Rules. So just by Googling that. And then also, just from what you've been told in the memo, you should have a broad understanding of the law that is hinted at. Not to the extent where you need to write an essay or anything like that, but just basically enough to give some cursory initial advice and say, and it's no big shame to say in the interview, oh, I haven't quite brushed up on that particular area, but that's something that we can go away and have a look at for you. And that can be a part of your like action plan going forward. And the client's not going to expect you to know like the exact pinpoint in a case that will help their case, for example. So that's completely normal. And you should be aware of the alternative dispute resolution processes, so negotiation, mediation, and arbitration, because that's something that kind of shows your your good client interviewing skills is you need to pick up on whether your client wants to go to court or whether they would prefer to negotiate or mediate and talk to someone else, rather than going through this expensive, potentially timely process where that can cause them a lot of stress. So that's just something to be aware of, and always offer that up and say, look, here are the pros and cons of each option. Like court might give you this, whereas negotiation might give you this, and that sort of thing. So always bring into an interview. This is something that my partner and I always did. We had a little notebook and we had, okay, this is exactly what we need to address in the introduction, and this is what we'll go into in the rest of the interview. So your kind of like plan of how long you're going to spend on each part of the interview. Bring in any notes that you want. There's no restriction on that. I mean, obviously you don't want to have a massive binder because that's intimidating to the client, but as much as you want and feel confident and comfortable with, and also just bring a notepad or a book to write notes as the client is speaking. Bring any props like tissues. Some people bring water jugs and water glasses to offer to the client, or mints or chocolates. Like I've seen little like snack things being brought in before, but mainly you want something like a tissue that you can refer to in the introduction, something like, please make yourself comfortable. If you find yourself, needing to take a break, needing to clear your head, have a glass of water. If you need to use the tissues, please do, that sort of thing, just as a way of engaging more with the client and making them feel more comfortable. And then you are given the opportunity to set up the room how you like. So you'll often just be given like a big desk and 3 chairs. So you can move the chairs however you want. I've seen all sorts of variations, but typically you don't want to seem like it's an interrogation. So often there won't be one chair on one side and then the 2 chairs on the other where you sit. So it's like often, this is hard to demonstrate on Zoom, but often you have one person and then one person on like the corner and then one person like facing the client. So you're kind of both looking at them on an angle, but not like straight on, like you're like, tell me everything about your life. Like it's not an interrogation. I hope that made sense and that wasn't too awkward, but also bring a timing device. So my pro tip is bring in your phone, put it down in front of you and put it on airplane mode so you don't get any distractions, and set your 30-minute timer, or you can start a stopwatch and see how long you're taking. And then wear professional dress. So blazer, skirt, suit, anything like that, just look professional. So, okay, the time starts with the interview as soon as you open the door of the room for your client, and it only ends when you see them out of the room again. So it really encapsulates basically the entire interaction. So as soon as you open the door, you want to be switched on, you want to be, in that I'm a lawyer persona, and you want to welcome them to the firm and say, welcome to, Smith and Smith. Please come in, make yourself comfortable, have a seat. Like I said earlier, acknowledge your props, like if you want to help yourself to some water or anything like that. Then you want to make a little bit of small talk. It's not said here, but small talk is a very important way of initially connecting with the client and not seeming like you're rushing into basically, rushing through the interview, rushing to get them out the door. So you want to, I always say with small talk, never assume anything about the client. So you can't assume that they drove to the interview. You can't assume anything like that because they may have caught the bus. You don't know their financial status. So good things are like the weather, current events. So like when the Olympics are on, that was a good way of, have you been watching the Olympics? Something like that. And then once you've, had one or two small talk points, you then go, okay, we're going to start the interview now. Can we get your details? Some people do it in the way of, our secretary has got your details, but we'd just like to confirm them so that we can keep in touch with you, something like that. There's no set formula for that. You do want to outline the interview process. So basically say, this is a 30-minute cost-free, obligation-free appointment. As I mentioned earlier, address the confidentiality in there. So say this is confidential pursuant to the exceptions. And say, as I'm saying with the structure, you want to tell them, okay, we're going to go through some housekeeping matters like the confidentiality and that sort of thing. Then we're going to hear your story, and then we'll ask you some clarifying questions to make sure that we have all the appropriate information so that we can give you the best advice and best initial response possible. And then you want to wrap up at the end and tell them that, you know, after we've given you that advice, we'll spend a couple of minutes at the end just making sure you understand what we've said to you and basically asking for some more detail. So, for example, you might want to ask the client for receipts. You might want to ask them for, you know, conversation records or further documentation. And you can say that at the end, like as a little bit of an action plan with the client. And so that's kind of how you step it through with them, like very simply, just kind of quickly, like how I just said it. Also, an important one is costs. So like I said, it's a cost-free appointment in this fictional universe. But you can say, oh, if you have any concerns about costs, we can set up a payment plan, or we can direct you to legal aid or community outreach programs, that sort of thing. Like I said, you can't assume anything about the client. You can't assume that they can afford your services. So just a little sentence in there basically being like, we're aware that not everyone can afford our services, so here are some other options. And then complaints. So I think this is what my partner always said, so I don't have it kind of like cemented in my brain, but it's something like, if you have any complaints about how the way that we handled your matter, the way that we handled this interview today, please feel free to get in touch with us, our partner, or the Queensland Law Society, if you wanted to express any concern, something like that. Not the smoothest. You can tell that wasn't my side of the introduction, but something like that. And then you want to kind of jump in after you've gone through, you know, that checklist. So the introduction is an easy way to get basic easy points. So you really want to tick off all of those things. Otherwise, you're, you know, missing out on marks essentially. But then you want to jump in and say, okay, our secretary's informed us of X, Y, Z. Do you want to tell us a bit more? Or do you want to let us know what's been going on? Just something not too casual, but also in a way that kind of sets them up to be comfortable, because they've been given a script and they're waiting for that prompt from you to go, okay, I can start reading this like 10 paragraphs of information to you. Right. So like I said, they are given a script. I hope you can see on the screen. This is an example of a part of the script that the client is given. So they will basically read everything that's not indented, if that makes sense. So they would read, I'm a parent to 7 children, blah, blah, blah. And they go through all of that. And then once they're finished, you would say, okay, thank you for sharing that with us. We'd like to now ask you some questions to make sure we've got all of the information. So this is something that I always hammer home to people that I judge. You want to ask your clients objectives. So you want to ask them, what do you want to get out of today? What are your objectives? Something like that, because every single client script, they are given a page that has, these are your objectives, and they'll have like 3 points, and they're just waiting for you to ask them to what their objectives are, and they will tell you, and that can guide the way that you ask them questions. So a good way that you can phrase your questioning is, okay, now we've heard your objectives, let's ask you some questions about objective 1. And that'll help kind of guide your structure, and it will help you in terms of keeping on track with your partner as well. So that's one thing, is like, you need to kind of be aware of where your partner's at in terms of, are they ready to move on to the next objective or the next point in our questioning, whether you're tackling it by objectives or whether you're tackling chronologically. And you are able to kind of look to your partner and say, are you ready to move on to the next point, or that sort of thing? That's fine. Don't do it too much and don't make it too artificial. But just there's no shame in being, like it says on the slide, you want to be on the same page as them. You want to make sure that you're covering all your bases. But yeah, you're questioning your client on things that you need more information on. So, if you're asking about defamation or something, you need to know, are there any defenses or something like that? So you need to ask them those directed questions, which you'll have learned about from your research. So if you studied the defenses of defamation, to use that example again, you might want to know, okay, is there any possible merit in arguing for, truth or something like that? I did torts a few years ago, so a bit rusty there. And then you want to funnel your questioning. So you want to go from broad to narrow. So you might start off with a broad question like, can you tell us a bit more about that conversation that you had with Mr. X? And then they might tell you something else. And then that might lead you to, okay, so what were the exact words that are used to the best of your memory? Something like that. So they often will have, like it's on the screen, confidential facts, and it'll say, if you're asked about this, say this. And sometimes, they'll have even further indents. So there might be confidential fact, if you're asked about this, say this. And then there might be one underneath that. And if they say, it might say something, if asked about, specific date, say this. So that's the way that the funnel approach really helps you get out as much information as you can. And it's really testing your ability to ask all of the questions that would be crucial and informative for you to give the best advice. So the judges are sitting there watching you going, okay, they've asked about these things because that would give them the appropriate information to provide about a defense or about a cause of action and that sort of thing. So it's a really, really useful way to show off your skills and show off a little bit of your research as well. Okay, ethics and client behavior. So ethics, problem writers like to throw in sometimes a couple of sticky issues. So clients might get aggressive with you, they might swear at you, they might threaten you, all sorts of things. As soon as that arises, you do need to address it. Because think about it in a real life situation. If someone starts threatening you, you're not going to go, okay, we'll get to that in 10 minutes. Like you want to get to that as soon as possible. There are often basically non-legal things that clients might also want advice on. So for some reason, problems often involve substance abuse issues or something like that. I don't know why, but that's just a little tip from me. So if there's any sort of hint on something like that, you want to go, okay, would you like any advice on that point as well? And then the client, if they're a bit cagey about it, maybe, back off and just say, hey, like we're not, hey, because that's not professional, but just say, we are able to provide you with counseling. We are able to link you with community programs such as Alcoholics Anonymous or whatever the particular situation is, and just do it very tactfully and do it in a way that you're comfortable talking about it with the client and the client is comfortable hearing about it, because they may shut you off and say, no, I don't want that. I don't want to hear about it. And that's just something you need to gauge when you're in there. But my main advice that I give to people about this particular point is I'm like, just be a person, just be someone having a conversation with someone else, and think about how you would react if someone told you that they had a drinking problem. You would say, okay, I'm sorry that you're going through a tough time, or whatever the case may be. Would you like some help? And that sort of thing, just something like that. Okay, so advice. So once you've squeezed as much information as possible out of the client, you really want to start giving them some advice about 20 minutes in, because think about it, half an hour is not too much time, so you don't want to spend heaps of time asking them every single question, but at the same time, you want to strike a balance between getting information that will help you with the advice. But it's really important to manage your time as well as you possibly can. So that's why we have that guideline of 20 minutes. Obviously, if it's quite a long story, you might start advice at about 22 minutes. And you just signal that to the client and say, okay, thank you for that further information. We might start to give you some preliminary advice now on what we've heard. So one thing is you don't want to say outright that they have 100% chance of success. And you don't want to say outright, this is exactly what we think the issue is. Because if you think about it, it's just a preliminary advice. You don't want to, I guess, catch yourselves out later by saying something and then it turning out to be wrong. So everything that you can say can be qualified and say, look, this is just from the information that we have. This may change if we receive further information down the line. And this is, just some preliminary advice. We may need to go and research further, something like that. So you kind of want to structure it in response to the client's objectives. That's the best way that I think that you should do it. So if they've told you, oh, I want to know what the consequence of this contractual clause was, you want to really address that in your advice, because if you miss out on that, you're not really giving the client what they've asked for. And you want to identify any legal issues and explain them in non-complicated legal terms. So you don't want to be throwing out too much legal jargon. You definitely don't want to be using case law or like particular complicated concepts that you've learnt. You can use that later in the interview with the judges, bring out all the stops at that point, but don't use it with the client, because if you think about the people in your life that are non-legally trained, they will have no idea what you're talking about. And it's not a very good way of connecting with the client and making them feel like they're comfortable and that they're being heard and provided with accessible information. So you may, like I mentioned earlier, you might need to note any further information that you want from them or further documents, and provide a direction as to where you're going to go from there. So say, okay, next steps might be we'll collect, the further documents, we'll reach out to the other side, see if they've got lawyers, if they're represented. And then if you've discussed, mediation or that sort of thing, and say, this is the process for mediation, or if it's a family law matter, this is the process for filing for divorce or something like that. But that's something that you'll have looked at in your research, and you can have like a little cheat sheet in front of you and say, okay, this is the next step. This is what we're going to do. And like I said, you don't want to say you have a 100% chance of succeeding, but you do kind of want to give them an indication. And you really don't want to give the client hope that they have a case when you think that they don't. And don't be afraid to say that to the client. And don't be afraid to say, unfortunately, just based on the information you've told us, I don't think that you have a case for defamation. You don't have a case for nuisance, whatever it is. But we are happy to look at it further if you'd like, and look at further evidence or documents or anything like that. Because sometimes that is part of the test of the client interview, and that particular material is that they don't have a case, and you need to tell them tactfully that they don't. Okay, so conclusion. So after you've given them, your preliminary advice, you do have a case of negligence, but like I said, I just go back to the not using legal jargon. If you tell someone that they have a case in nuisance, or if they have a case in negligence or anything like that, you want to explain the kind of sub-points of what nuisance involves or what negligence involves in a very accessible way. So just say, okay, nuisance just means this, and this is kind of what we might need to prove. So this is why we're asking you for this information. And you can kind of tie it all together in that way, because if you explain it accessibly and you explain defamation is a good example to use, because there are those like definite points that you need to show. And you can really tie that into not only a way of explaining it clearly to the client, but then you can tie it into your action plan in terms of getting further evidence. And you can say, we need this further evidence because you need to prove this, or something like that. But like I said, you might want to get receipts, you might want to get conversation records, email phone records, whatever it is. You'll explain the client agreement. So you'll just say something like, on the way out, please, our secretary will provide you with a client agreement. Please feel free to have a read over it and have a think. This will include a copy of our cost schedule. As I mentioned, you might want to say, look, we understand if this is not an option, we can put you in touch with legal aid, or provide a payment plan, which is, you know, maybe more suitable. Provide a direction to the client. So if it's a particularly maybe not friendly matter with the other party, so maybe they have, you know, had some harsh words and that sort of thing, maybe say something like, if they try and contact you again, I'd advise you to let us know so that we can help you draft correspondence in return or correspond with them on your behalf, something like that. And then pleasant goodbye. So you just want to say, thank you very much for your time. I hope that we've provided you with some initial guidance. Have a pleasant day. See them out of the door, that sort of thing. Okay, so some tips and tricks. You really want to maintain a 50-50 split, or as close as possible, between the speakers. So with you and your partner, like I said, my partner and I always had, these are your parts of the introduction that you say, and these are my parts. And we had them highlighted in pink and purple, I think it was. And when you're asking questions, a good way to go is I ask a question, my partner asks a question, and back and forth. If they're on a kind of, you know, if they're on a track and they've got something in mind, maybe don't interrupt them and let them ask 3 questions, but in a row, but obviously try and balance it as best as you can. Pick a good client. I can't emphasize this enough. Pick someone who you know, they don't have to be an excellent actor, but pick someone who you know will be confident with speaking a little bit off the cuff if they need to, and reading off a bit of a script. You really want to be organized and be on time. So I think the direction is always, the client needs to be there 15 minutes before your actual time slot, and you need to be there 10 minutes before. That's just so the client gets a chance to read over this big, like 5-page or however many pages the script is, document, and see what they need to say under this pressure of the half an hour time slot. And that just gives you a chance to get settled, you know, get in the zone, that sort of thing. And like I said before, time management is really crucial because it is just a half an hour thing. So you really want to keep an eye on, okay, 5-minute introduction, 5 minutes initial story and initial questioning, then like your main questioning. Once you get to about 20 minutes, you want to start giving them advice, and then wrap up with 3 or 4 minutes left. That's really rough. Don't take that as gospel. But yeah, and also don't complain about the problem to your judge. Oftentimes the judge wrote the problem or knows someone who wrote the problem, so just be wary of that. So any further information that you may need, obviously you can ask me. If you have any burning questions now when I've just finished the presentation, you can read the UQLS competition rules. So it's called Raise the Bar. Oh, sorry, that's the competition handbook, but they're linked. Watch the how-to videos examples on YouTube. So I believe last year they uploaded a fake client interview that my partner and I did as an example. I don't know if that's still accessible. I think that might be, but I'm not sure. And then keep up to date with the UQLS competitions Facebook group. So any pertinent information will probably be emailed to you, but keep an eye on the Facebook as well. And reach out to the internal competitions team so the people running the competitions will be the best equipped to answer your questions about the competitions. This is something that wasn't around when I was competing, but teams must register with a client at the start of the competition. So just be aware of that one. And cool, thank you. Are there any questions?